I think we could start, and thank you for showing up after lunch and after the first session. We are going to talk about digital antitrust enforcement. It's a slight change with respect to some of the initial plans because one of our speakers, essentially a litigator, had to undergo surgery, so we needed to change it because it was at sort of the core of it. But we decided to make an even better presentation, and we will have the pleasure of having a stellar panel today, with starting with Giuseppe Colangelo. He's professor at the University of Basilicata and Lewis, and Stanford Fellow, and he's probably one of the most prolific writer about law and economics and antitrust in the digital sector. He will be telling me off afterwards, but I wanted to say that. And he will be using his broad knowledge talk about how different jurisdictions have been using or developing tools to address the market power in the digital sector despite the DMA existence. Following that will be Cecilia Carli, who is Senior Associate at the Antitrust Department of Freshfields, and she will be touching upon one of these tools developed by the Italian Antitrust Authority, and in particular the abuse of economic dependency in the digital sector, which is its own specificity. Then we will move to public enforcement in the structural world, so with M&A, and Filippo Alberti, Principal Associate in the same group, will be talking, not surprisingly, about Illumina Grail and the calling powers that were just mentioned by Professor Iossa, and how and good ideas on how the public enforcement in the M&A spectrum will operate. And then we'll conclude with Alessandro Di Gio, counsel at Freshfields Antitrust Department, who is going to talk about what Professor Iossa just mentioned about the new tool that the Antitrust Authority in Italy has, so market investigation powers, and how that may play out in the digital sector. So without further ado, I'll pass the floor to Giuseppe, and please, the floor is yours.
It's working, okay. Despite your very kind introduction, my only contribution to this panel is because of this picture. If you are unable to recognize it, it's because you are too young, unfortunately for me. And this is a picture that it would help me to describe what I'm trying to share with you, that is actually not the escape from New York, but is the escape from DMA. Because it seems to me that what we are witnessing is an ongoing tentative delivered at national level to bypass the DMA. Of course, someone else will tell that this is just a matter of complementarity, but actually we are seeing, and we may already seen from the very beginning, that actually the DMA may struggle in coordinating its enforcement with the traditional and new tools that has been enacted at national level, which include not necessarily national competition rules, but includes the abuse of economic dependency that is not necessarily new. Some of the version of the abuse of economic dependence has been updated in some countries recently, but I mean, again, it's not a new tool. We have also seen the possibility to tackle conduct and behavior that are addressed by the DMA under traditional rules in terms of unfair commercial practice, and then, as we know, there is an increasing interest in adopting the new market investigation tools. This interest, I would say, is not genuine from this perspective, because no one, at least 4, 5, 6, 10 years ago, was so concerned about to have this new market investigation tool. The only one was the UK and in part Greece that actually enforced it just one time related to gasoline industry. Apparently as an externality, then I let you judge if it is positive or negative, but as an externality of the DMA, we see that there are several countries that are adopted or are thinking about adopting the market investigation tools. That in terms of relationship with the DMA, it's even more interesting because these tools, despite these may belong to competition law, actually is a regulatory tool. So in this situation, there is also the need to find a way to strike a deal between a regulation and another regulation. The previous tools are, I would say, unexpected backdoors that, that DMA left open, because as you know, DMA described itself as regulation, so left the door open to several antitrust potential intervention. And I would say that not necessarily these are conflictual intervention. I mean, from the very beginning, we all know that there's been government and national authority that self-proclaim themselves as a friend of DMA. That's the reason why you may look at the slide in terms of frenemies, because there is a well-known saying that if these are your friends, you do not need enemies. And well, it was expected that at national level, competition authority was not so much willing to leave all the digital spot to the European Commission, despite of the fact that probably, at least from my point of view, the main, if not only, benefit that comes from the DMA is the centralized enforcement. And I would say that also from the perspective of targeted undertaking, the designated gatekeeper, if they have to spend the word supporting the DMA, is because they expect to have a uniform intervention. However, we have to be honest enough to recognize that after the DMA, apparently the antitrust competition policy scenario is more fragmented than before. And that's a problem, as a matter of fact. I was saying that not necessarily these interventions are in conflict with the DMA, not because they are not formally in conflict of the DMA, but it seems, at least to me, that the European Commission is prioritizing the enforcement of some of the obligation of the DMA. So the European Commission is apparently aware of this, enable, because of the working load and the limited resources, to take care of all the obligation. And so, for instance, they are focusing on vertical interoperability and mobile ecosystem, but they are unable to take care of all the other obligations, because that's the only way in which I can justify because the fact that the European Commission apparently is not so much concerned to see several national antitrust authorities taking care of apparently the very same obligation under the DMA according to national provision and different type of national provision. And just to complete this overview, again, to be honest, this process has started because of what we may define as sort of German exit in terms of antitrust. Because actually the country that opened this trend of new tools, new national tools is actually Germany. Germany adopted literally German DMA. I may call, I'm not sure that many of you are going to disagree with me, I may call the Italian abuse of economic dependence a sort of mini DMA, but the German one is definitely a DMA. And of course, and the German introduced also a market investigation tool and so on and so forth. So definitely once the German decide to follow this path, I actually expect that more countries are going to follow the very same pattern. Especially, I would expect that France was going to follow the Germany. Yeah? So I was pretty surprised about that. But again, just to conclude, it seems to me that at least from the enforcement perspective, one of the main questions that may raise because of the introduction of the DMA is its own justification. Because if you do not have a uniform enforcement of the regulation, your very basic justification is going to be undermined and is going to be questioned. Now, this is a concern not only for academics and for practitioners, but I would say from the single market, due to the fact that We have the letter report, the Draghi report, and apparently the focus is on the single market. This does not seem so much single in Europe.
Before, no, thank you, Giuseppe. Before passing the floor to Cecilia, just a quick question for you, just on the basis of this short but exhaustive overview. What do you think is the likelihood of success of the DMA as a regulatory tool?
And this is a quick question.
Yeah, quick question for all, you can have a longer answer.
I mean, difficult to answer, not only because predicting what is going to happen in the near future is quite nearly impossible, but because honestly, we are even figuring out which are the metrics of the DMA. With a colleague of mine, recently we tried to address this topic looking at what is stated in the DMA and how can we measure the success of DMA, because of the goal of the DMA, fairness and contestability, and the primary beneficiary of the DMA that sometimes, many times, our business users, sometimes our end user, it's not easy to measure the success of the DMA. For sure, in terms, I would say, when it comes to contestability, it's easy to measure the result. If you are able to increase the number of players in a certain market, of course, you may say, I've been successful. When it comes to benefits that you deliver to consumer, more puzzling. I mean, we are all aware of the, I may say that could be an outlier, but we are also aware of the Google Map situation. I don't know whether the Google compliance is strategic or not, but for sure, it is well known all over the world that in Europe you are unable to reach the map just clicking. You are more than one click away from the map. I will say that at this point, we may see some light and some shadows. When it comes to the shadows, definitely problem in terms of litigation. One of the justification is we want to reduce the number of litigation. Doesn't seem so. If we look compliance report, if you look reaction to compliance report, proceedings and so on and so forth, I would not say that you are going to reduce litigation, first of all. Second problem, fragmentation in terms of shadows. Lights. The main lights, the main benefits that I see so far, that is also, I do think, the main challenge for the DMA is to deliver remedies. Especially when it comes to technical remedies, interoperability, this should be the added value of the regulation in comparison to antitrust enforcement. So to me, it is welcome the fact that the European Commission decide to take full responsibility in proceeding with a technical specification proceeding when it comes to vertical interoperability, Article 6.7, so on and so forth, because it means that the European Commission is going all in on the possibility to deliver effective remedies. And we know that when it comes to antitrust enforcement, it's not a matter of tier of arms, it's not a matter of legal requirements, but if you look at Google Android, for instance, the Italian case, you have so many questions when it comes to the way in which technically you may enforce your claim, that I would say that's a situation in which I expect a significant added value coming from the regulation in general.
Okay, so it's a sort of a wait and see in a complex world approach. Cecilia, the floor is yours. Let's talk about...
Thank you, Gianluca, and good afternoon, everyone. So I would like to start maybe from what...
Does it work?
Does it?
Okay.
I need to stay closer to the mic. Yeah. So I just wanted to start my brief contribution to the panel with one of my take from Professor Colangelo intervention, which is that one of the complexity really comes from the interplay of the different layers of regulations. And I think that the Economic Dependence Institute really squared nicely in this framework because it comes with its very own complexities from an objective and subjective standpoints. So what I would like to do today is just leave a few food for thoughts for the audience to think about how the new provision, which has been increasingly applied in Italy, and certainly we have seen the very first application in the digital space, and some of us are involved in that case, so I won't comment on that one, but I think there are a few principles and questions which are worthwhile addressing. So the first one, just as a brief reminder, so economic dependencies aim to tackle conduct in a situation where you have So a significant imbalance between counterparties in a contractual relationship, and essentially a presumption of existence of economic dependency has been introduced for certain digital platforms. So the first question is it really applicable in every single circumstances where you have a digital platform involved? And the very wording of the provision actually kind of limit, or seems to limit it in two ways. On one side, where the digital platform provides intermediation services. On the other side, where the digital platform has a determinant role to reach users or suppliers. So just to make a visual example, just let's assume I am the owner of a marketplace or a digital platform, and I have a contract with a facility management service operator, for cleaning services in the offices where I do carry out my activities. Is that, of course, this is of course an extreme example, but just to say that in this case I would not see the provision of intermediation services on the digital platform side. And in this case, as an important question, is it really a determinant role for the counterparty in contractual relationship? Maybe not. And the second question open for, I think, for reflection is the very concept of the determinant role for the digital platform. What does it mean? It's slightly debatable, because someone can think it should conflict with the very notion of dominance, the antitrust concept of dominance. Others could reconcile this with situations where you have an access problem for an input facility, an essential facility type of concept. Others could consider it connected somehow with, let's say, for certain operators, the concept of the gatekeeper, where, of course, a designation is in place. And actually, I think the point of reflection here is just looking back at the real function of the institute. So this is about significant imbalance in a specific context, in a specific contractual relationship. So I think when analyzing this concept, we should also look at the very specific case. What is the bargaining position of the two parties within that, and not simply, let's say, conflating other concepts which may come from other previous assessment in terms of antitrust or, for example, gatekeeper designation. So this is about the applicability of the presumption, which I think the conclusion is a bit of caution in terms of applicability and what exactly the scope could be. But let's assume the presumption applies. It's still a rebuttable presumption. So there's still some space for the platform to forward evidence to say that in that specific context it doesn't apply or is overcome. And I think in this space what comes to relevance is about one of the cornerstones of the Institute of the Economic Dependency, which I think resolves around the possibility to find an alternative which is satisfactory for the dependent company. And I think in this space, 2 points again. One is linked to what we just said, to the determinant role to reach customers, because somehow some could be tempted of conflating the two things. Because if there are alternatives, is it really a platform having a determinant role? If you can go to someone else, question, maybe yes, maybe not. Or what else should be relevant to define what determinant role is? What factors should I look at to define it? And is it any difference between factors that you should look at in the digital space compared to traditional markets? Of course, there may be some peculiarities of digital markets which are relevant. Let's think about, for example, multi-homing. So in a world where you have consumers or users which generally look around different platforms, can really one of them be considered determinant to reach those very users? And is there any difference compared to what factors which traditionally have been looked at in other markets? Let's think about the turnover, for example, which, according to case law in traditional market, has been one of those that normally comes into play. In that aspect, I think that the relevance of these traditional factors should not be, let's say, left on a side completely in digital markets as well, because when the share of the turnover generated through the platform is not material, for example, is that really let's say a factor suggesting that the determinant role is not existing there? and what market I should really look at for finding alternatives. Let's take my example of the provider of cleaning services. If the relationship at stake is about the provision of cleaning services, should I really look at the market where the digital company is mainly active, or should I look at the one where of the cleaning services in this example? And again, this is the food for thought, but I think we should really look at the specific market where the relationship is taking place. And then the third and very last point I wanted to discuss. So let's assume presumption is applicable. The digital platform didn't manage to overcome that, so the next step should be that of identifying an abuse. And legislative intervention introduced a list of conducts which could be considered abusive for digital platform. Of course, it's not a non-exhaustive list, so there may be others. And actually, this suggests that the variable space, variable perimeter that I was mentioning earlier, could come into play to see how other type of non-typified conducts could be captured as well. I think this comes again with 2 points of reflection, which I leave to the audience. The first one is that it's true that a different and variegated type of conducts could be, in principle, captured. On the other side, I think this should come with the limit again of the significant imbalance of rights and obligations, which is again anchored to the very core of the provision. And on the other side, there is always a bit of a trap there, which would create a sort of logical short circuit, meaning that we should not cascade from the existence of a presumption and of the existence of economic dependency, also the existence of an abuse. I think this should remain separate layers of the assessment, which should remain distinct. So just to conclude, I would say case law, and we will see, time will tell us how the authorities will interpret, but certainly it comes with its own challenges in the digital space as well.
Many thanks, Cecilia. Just one point that what you said raised, I think it's worth exploring briefly, and it's both economic dependency, particularly when enforced by the Italian Antitrust Authority, has to have a relevance for the market. So it is a substantive, as always, approach, not a formalistic approach. And how can you reconcile that with mainstream antitrust, with Article 102, in the particular a dominant position? So naturally, this is relevant also for the case we were discussing. But in principle, let's move away from that. But in general terms, how can you reconcile one, for example, a relationship with multiple platforms, and the presumption, which one is the economically relevant one for the dependency question, or other question is, if your counterparty of a digital platform is a dominant player in his own market. So what are you reconcile these two concepts? How can that be possible?
Thank you, Giulio. I think this is a good one. So closer. Sorry. So I think this points back to what we were saying earlier about the specific relationship under consideration. So also when you look at the impact on the market, you would need to look at how the conduct impacts the specific market where the abuse is claimed. So for example, we should not, I think, look only at the market where the digital platform is mainly active. You should obviously look at the market where the allegedly abusive conduct comes into play and what the effects there are. And I think taking the very same example I was using earlier, in that case, let's assume that you have a digital platform which separately under antitrust law has been defined as dominant in a market. Let's say the marketplace is my example. And then you have the cleaning service operator, and let's assume that itself is dominant in the very own market for cleaning services, but the abuse that the contractual relationship we are looking in this example, of course, is not the provision of marketplaces services. It's the one about provision of cleaning services. So the provocative question here is, can the cleaning service operator, which is dominant in the very same market where the abuse is allegedly taking place, be considered economically dependent on another operator, bearing in mind the notion, of course, of abuse of dominance And I leave the question to the floor, I think, just food for thought.
Let's leave it open. Thank you very much. Next, we are running on time, surprisingly, and for the panel I chair normally, actually the panels in which I participate normally run late because of me, but so you are much better. So Filippo, the floor is yours.
Yes, I would like to start from a little bit provocative question, if there can be a future for M&A digital transactions. We already know that the M&A landscape is getting more and more burdensome, and also companies are facing increasing obligations due to the clear broadening of the scope of the application of the UMR and the national merger control regimes. And this is I think due to two main aspects. The first one is the failure or the difficulties faced by the turnover thresholds based mechanism that were not capable to capture the many transactions and the famous killer's acquisitions. And in this regard, I would like to spend a few words on Article 22 of the UMR and the calling powers, and on the other side, on the merit of the assessment carried out by the European Commission recently. There is a clear update in terms of new theory of harm, and also here I'm probably going to mention the ecosystem theory of harm that is quite famous now. These things are to be also combined with certain provisions of the DMA, and in particular the obligation for the gatekeepers to inform the Commission in relation to project of transactions involving companies providing core platform services. And also the case in which the Commission can hinder the transactions where a gatekeeper is in the position of systematic non-compliance, when this transaction can enhance somehow this non-compliance. I think that also in the background we should consider also the FSR, the Foreign Subsidy Regulation, that goes in parallel to the UMR filing and somehow can contribute to at least slow down the closing of the deals. And as we know, it imposes burdensome obligations in terms of information to be reported to the Commission by the company. So if we take the first aspect, so the turnover threshold issues, I think that probably due to the killer acquisition and the transaction that escaped from the application of UMR, the Commission, starting from March 2021, has invoked a more appropriate or more frequent use of Article 22 of UMR, but we cannot avoid to read this tool in light of the recent European Court of Justice decision in the Illumina Grail case. And of course, according to the court, the Commission cannot accept anymore the request of referral from member states that are not itself competent for reviewing the transaction. We do not know if in the future this interpretation will be confirmed or in other cases, and especially if the legislation will be aligned with this position. But what we know for sure is that there has been a reaction, an immediate reaction, because if you consider the Microsoft Indigeon case, the 7 member states that requested the referral have decided to immediately withdraw this request. And talking about in a minute on the call-in regimes that have been adopted in the last few years by several authorities in Europe and also outside Europe. I don't want to spend much time on this because the Commissioner Iossa already said something, and also Giuseppe Colangelo before, but my only comment is that it is clearly a tool introduced for capturing, at least at the beginning, killer acquisition or transaction in innovative sector or in digital and pharma, while, for instance, in Italy, the application is so far related to traditional and brick and mortar markets. So let's see what happens in the future, and I've heard the words of Commissioner Iossa with that I found particularly interesting on this point. If we try to combine this Article 22 mechanism, naturally pending any consideration and confirmation or different interpretation of the Illumina Grail case, European Court of Justice decision, with the calling powers and the DMA obligation under Article 14, we could get to a hybrid mechanism, mix of non-traditional powers from national authorities and European Commission, according to which a gatekeeper should inform the Commission about the project of transaction. Then the Commission report this information to member states who are empowered to scrutinize the transaction for calling powers or similar can naturally become competent for the review of this transaction, and they can even refer to through Article 22 to the Commission. So this is an example of a mechanism that put the Commission, that at the beginning of this case was completely out from the competence to review the transaction, to become competent in reviewing it. I think that for digital players in general, the possibility to rule out at the beginning when approaching a merger or a transaction, the possibility to file a transaction under any possible applicable regime is getting very hard. And this has an impact on the contractual documents in terms of condition precedents, timeline, and effort clauses. So we should bear it in mind. And then going very quickly to the updates in the assessment by the Commission in the most recent cases that have been somehow confirmed and reverted also in the new market definition notice. I think that we can use as a matter of example Booking It Travelly with the born of this new ecosystem theories of harm from the opinion of some authors is that is a little bit weird in the sense that the booking that was dominant on the hotel agency travel services would like to acquire e-travel that was active in the flight OTA services, but this ecosystem and the fact that a consumer could be induced to remain on booking.com after having bought a flight, also for for finding the hotel solution was considered crucial, and somehow the consumer would be captured, and this naturally would hinder other competitors of booking to entry into the market. I think that in general the key points to be considered now from a more, let's say, assessment standpoint is that first of all, the use of a proper notion of counterfactual, because in the digital markets where the evolutions are very, very fast, this notion should be interpreted as dynamic. And I think that this is not an easy one. Let's think to what happened in several years ago in the UK for in the Facebook, Instagram case where the initial evaluations were completely different from the afterthoughts that emerged after. And also, if we compare the Facebook, Instagram case as a business success compared so in terms of predictability, the difference with for instance, the acquisition by Facebook of TBH that then has been closed less than 1 year after the acquisition. So here the open point is if it was a real killer acquisition in the sense of make and the activities of a competitor, or it was just a bad investment by Facebook. The second point, I think, is the attribution of the right value to some elements that have not been considered the key using the more traditional approach in assessing merger. For instance, hiring of people that instead was deemed as crucial in Facebook, Instagram, but also in the recent Microsoft Indigen case. And also, if we consider when we assess or making some evaluations on joint or joint control in the JV, for instance, we use naturally to focus our attention in terms of veto powers, for instance, on the appointment of the CEO or the SVO, and instead in a startup or for a digital tech, probably it is much more important the appointment of the CTO that is key and strategic for the management and of the activities. And then I think another an important point is the right definition of the market. This is somehow cleared and fully integrated in the new market definition, but as we know, this kind of digital markets or new market that are multi-sided markets and the product and services offered are at no price, they are not subject to the application of the SNP test rather than the S&Q test and other criteria like sustainability. So we don't know if the traditional theories are already overcome, but it is sure that the Commission has put a milestone in this sense with especially with the e-booking with booking it travel case. We don't know also if the horizontal merger guidelines will be reshaped in order to capture also this new theory of ARM. I think it was announced by the Commissioner, so we will wait for this. And I think that there is no coincidence between the application of the new theory of ARM and the fact that the two main other transactions that were expected to be scrutinized under this innovative theory of ARM were abandoned by the parties, so Amazon iRobot and Adobe Figma. So let's see what happens in the future, but we can appreciate that a lot of hurdles are existing for digital players in the merger.
Grazie mille, Filippo. So you made us keep up with the old tradition of being late in the scheme of things, but very, very exhaustive, very interesting. And I have also a question for you, which is something that of debated issue for many years. Now it's become relevant again. But given the sort of the complexity of the jurisdictional aspects, and the authorities now with the Lumina Grill decision judgment may feel less comfortable to refer cases, and they have calling powers, but sometimes these digital mergers may have much broader than national scope, so it's difficult for national authorities to sort of go after those. Do you see that the Commission may use other powers to try to tackle this in a legitimate way?
My immediate reaction, without thinking too much, is that yes, we can probably use Article 102 as the main practitioners are saying in the last few years. We have already an example of this with TowerCast, and probably the assessment of the market effects is naturally easier compared to an ex-ante one. I think that probably the TowerCast doctrine is maybe too young, because we don't have other applications in the sense that Proximus cannot be counted because the dynamics of the facts were different. And we are waiting for the closing of the investigation launched by the European Commission several months ago on Zoetis. So let's see if the TowerCast effect will follow on or not.
Thank you very much. And last but not least, the new powers of the Italian Antitrust Authority. And Alessandro, the floor is yours.
Thank you, Gianluca. So yes, I'm gonna talk about, basically I'm gonna face the question as to whether the new so-called superpower of the Italian Antitrust Authority are relevant, should be or not, or to what extent applied to the digital and tech sector. Which may trigger by some fairly straightforward answer saying, yes, of course, because that's where all of this comes from. All of the debate about the new competition to new powers, all of that come from the digital sector. But I think we can gather already also from what we've heard before, including by Giuseppe, that clearly the answer should be more nuanced. I'm gonna briefly cover the background. My job is gonna be far easier in that respect, given what has been told already about the new superpowers of the Italian Antitrust Authority and all the debate surrounding that, not only in Italy. And then I'm gonna focus on the legal and policy reasons which may be seen as either supporting or putting obstacles and limitations to such application to the digital and tech sector. So in terms of background, as I said, by now even the non-Italian audience is fairly familiar with the fact that in Italy we have new powers for the Italian antitrust authorities which can adopt behavioral and or structural measures in case of competition problems resulting or ascertained in the context of a sector investigation. And we're gonna completely skip all the story behind how we came about that piece of legislation. Probably not an ideal way of thinking of a legislative path in terms of democracy in many regards. But we're gonna skip all of that. So we are faced now with those superpowers, and clearly, as already mentioned, those powers fit in a broader context and broader debate. And in that respect, clearly, the new competition tool envisaged and discussed and consulted upon by the European Commission in 2020 is an important benchmark. And sometimes we do still hear voices about the opportunity or possibility of somewhat defrosting that tool for the futures. Then again, of course, everybody's very familiar with the UK market investigations experience, which is an important benchmark necessarily for the Italian antitrust authorities as well. And reference has already been made to the fact that there are many national regimes which have either already been adopted or are under consideration in other countries. And all of these regimes have a broad scope of application and have indeed the potential of being applied to the digital and tech sector. So why don't we move on and we start focusing briefly on what legal and policy reasons support the use of the superpowers by the authority or new competition tools in this sector. Well, first starting point is of course the absence of scope or sector limitation in the Italian law, but as I said, that applies to other legislations in other countries as well. The very origin of the superpowers by the Italian Antitrust Authority do suggest that the legal sector, or the digital sector is of interest and is relevant for those power, and in particular the topic which has already been recalled about the algorithm parallelism, which has been also identified in the debate around the new competition tool as one of the areas where a new competition tool type of instrument may be a sound way of stepping into filling up regulatory gaps. Then I would say that the recent activism of the Italian Antitrust Authority and other national competition authorities in pursuing antitrust cases in the digital and tech space, and even for global conducts and even for matters bound to be covered by the DMA or other sector legislation, suggests that we may expect the national competition authorities in Europe will not be shy in applying any new tool in this area. The experience of the CMA market and sector investigations provide also some indication of application in the digital sector, probably to a lesser extent compared to other sectors, but we do have even very recent cases in those areas, although there are legal novelties there as well. And I mean, overall and ultimately, as I said already, the broader debate about the new competition tool some years ago triggered a somewhat widespread consensus that there would be room for applying such a broad regulatory tool, particularly in the digital tech sector, because of some of the inherent features of those markets and some of the market failure which are regularly observed in those areas, such as absence or insufficient multi-homing, networking effects, tipping effects, and all of those aspects. If we move, however, to the legal and policy limitations which may run against or at least suggest a cautious application of the new powers and in general of new competition tool-like instrument to the digital sector, we can think of various arguments or reasons. The first one is fairly traditional, and it has been heard also in the more traditional antitrust sector, though with no big success, is the fact that clearly there is an argument that particularly in the digital sector, many of the issues and the problems have a global scope, and sometimes national competition authorities may not well be well placed to address those issues. And clearly this debate also links to the discussion in the context of the DMA about the choice of a centralized enforcement as opposed to a decentralized enforcement, and we know that some criticism has been drawn by the choice of centralizing the DMA enforcement almost entirely in the Commission's hands. Another argument is indeed, and this links directly to Giuseppe's presentation, so I don't really need to say much more about that. It's the fact that, of course, there are multiple concurrent and relevant regimes which are relevant and can successfully be applied to the digital markets. And then, of course, there's the big question about sector regimes, and particularly the DMA. And so the question as to whether and what extent, despite the DMA, there will be still room for applying a new competition tool instrument of the superpowers by the Italian Antitrust Authority to gatekeepers, to designate the gatekeepers, and in respect of their core platform services. And here there is a fundamental, there are fundamental legal questions of interpretation of some key provisions in Article 1 of the DMA, for which we don't have clear answers. The interpretation of those clauses is not straightforward, and we'll see when and whether we'll receive guidance in that regard by the European Court of Justice. Then a further thought may be that, after all, the new competition tool, which was envisaged by the European Union, was eventually replaced, we can say, or absorbed, depending on how you look at it, by the DMA. So you may consider that as a choice of underpinned by the idea that an ex-ante specific regulation with specific obligations may work better in this sector as opposed to general powers of interventions. And so that may lead to the question as to whether it is instead right to take a different course of action and different path. Not sure what happened. Okay. When it comes instead to national powers with superpowers, although clearly that also must be seen against the refreshing debate about the opportunity of having a new competition tool even at European level. And there is also an interesting parallel with the UK experience, given that in that case there were market investigations powers, and nonetheless the UK thought that for the digital sector it would have been best to introduce a regime of ex-ante regulation like the DMA. But at the same time, it is worth noting that within the sector legislation of the UK, there will also be a dedicated sector investigation for the digital sector. So it will be a combination of things. And then I think the last input is about the fact that there are, of course, many different market failures and theory of arms which are usually recalled in the digital and tech debate. Many of them, in different ways and to different extents, have been deployed or used or argued as reasons for having new competition tool or now the superpowers by the Italian Antitrust Authority. Probably in light of the presence of the DMA and other legislation, it would be important also for the sake of legal certainty to further enhance that debate and identifying really what of those market failures do really need an intervention by means of these new powers, and those theory of arms which instead are possibly already effectively addressed by the other instruments. And so, for instance, when it comes to unilateral conduct relating to market power, one thought maybe that is already probably addressed by the existing legislation and the choices which have been made in that context, whereas possibly in other contexts, and so let's say in horizontally related theories of harm, such as tacit collusion or information asymmetry, there may still be room for a need possibly for this instrument. But in that regard, the fact that there is, at least looking at the Italian case, there is no guidance on what kind of market failures will the new powers used for. And that was something which aroused also in the discussion and the response by the Italian stakeholders to the consultation to the Italian Antitrust Authority's consultation on the procedural rules. So there was a request for having clarity on what really the competitive issues should be addressed by that legislation. That didn't make it to the final document of the Italian Antitrust Authority, but somewhat understandably so, because the scope of that document was procedural. Nonetheless, it does feel that there is a gap in that regard, and guidance, if not even regulation, will be necessary, or anyway very welcome to have a greater understanding of what really the application of those powers should be in general, and particularly so in the digital and tech space.
Grazie mille, Alessandro. We are running out of time, but I'll, instead of asking you questions, I'll ask the audience whether there is any reaction to what we have said.
Given that I happen to be here, I'll make 2 comments. Very, very interesting session, I think, personally. Lots of food for thoughts for us. And it's always very good to hear, your perspective. And of course, we take it into account. In thinking, of course, of these new powers, one of the things I in my mind, I think, is that more than going back to Avvocato Di Gio? No, Alberti, yes. More than filling regulatory gaps, I think it's more about filling enforcement gaps. Of course, enforcement gaps may exist because there is a regulatory gap, and that's why we have the opinions of regulators, and they are involved. But they are a competition tool, and if you think also of the genesis of it, no, it's mainly enforcement gap than the regulatory gap. Although, as I said, collaboration is needed. And the other thing about instead guidance on the market investigation, I see the point. It's a very powerful tool and currently very wide. And we thought about this. At the same time, again, the world is evolving so much that if you were to sort of list conducts that may raise or issues that may raise, they may become old very soon, or the sort of not be your priority, and instead you want to look at other things. I think what is important is to think that these market investigations have a first stage, for us a very collaborative stage. It's where we study the sector. We have a call for input, for example, in educational publishing. It should not be thought immediately as we're going to impose remedies. So there a lot of the business, there will be business as usual, I think, a lot. And in fact, we can end the investigation simply through recommendations, right? We don't have commitments to the whole market. So that's why it's also not a regulatory instrument, because we identify the parties. We're not telling the market what it should do. So, okay, but thanks.
Thank you very much. I think we are done, and thank you very much for your patience, and thank you to the speakers for this fantastic presentation, and thank you again.